Hello everyone, this is Andrei JINGAN. I am a California licensed estate planning attorney. Today I will discuss why estate planning matters in California. This is not a legal advice and is rather provided for high-level illustration purposes only. You should consult with a qualified professional before making any legal, tax, or investment decisions. Today, I will cover the basics of estate planning, discuss the purpose of estate planning, discuss how tax laws have changed recently and why wills and trusts signed a longer time ago need to be reviewed now that no one owning less than 6.6 million per individual should worry about estate taxes at this time. I will show you how wills and trusts can be drafted today to take advantage of the new tax laws and how to find an attorney you will be happy to work with. Our first section, the purpose and the goals of estate planning. The goals of estate planning can be summarized as I want to control what I have all my life as long as I'm able, then leave what I want to whom I want, the way I want, when I want, at the least possible cost in fees and taxes. Notice that taxes are the last of the goals stated here. The first three goals are personal, leaving what you have to whom you want, the way you want. There are wise and unwise ways to accomplish these personal goals, and in today's planning environment, you have many more planning options now that the threshold for estate taxes is so high that few Americans will face them. As a counseling-based estate planning attorney, I realized that planning for your estate should focus on your family, your values, and your legacy. Traditional estate planning has often just planned for your finances, which are your cash and investment accounts, your life insurance policies, your home, and all of your personal property. Proper planning not only plans for your financial well-being, but also your personal legacy and the financial well-being of your heirs. Let's discuss all the goals of estate planning now that estate tax savings are no longer the primary ones for most people. Give what I have to whom I want, the way I want, and when I want. Care for self during lifetime, such as incapacity, healthcare decisions. Care for and protect others, such as surviving spouse and children. Minimize or even eliminate probate. Fulfill your charitable intentions. Pass on values and ideals to children and grandchildren. Maximize assets distributed to your loved ones, and protect assets from creditors for generations to come. A few questions to consider. Do you have a will or a trust? And if so, has it been reviewed in the last 2 years? Do you have any jointly titled assets? Does your current plan provide your heirs or beneficiaries with asset protection against creditors, divorce, and lawsuits? Are you concerned about any delays and costs your estate might incur if it goes through probate when you die? Are all your heirs 21 or older and financially responsible? Is this your first marriage? Do you have stepchildren? Are you concerned with family disputes arising from inheritance issues? If you were to become disabled, are you certain that your health care and financial wishes will be honored? Here are three definitions for us to understand as we move forward. When I say the word estate, I am referring to one of two kinds of estates. First, your probate estate consists of those assets that require your local probate court to oversee when you die so that your creditors get paid and your heirs receive what they should receive. Your goal always should be to have nothing controlled by the probate court when you become disabled or die. A properly funded living trust will pass your asset to your heirs without a probate court's involvement. Second, your taxable estate is your net worth, which is the value of all your assets less all your liabilities, regardless of whether any of those assets are part of your probate estate. The value of your taxable estate is what determines whether you have an estate or gift tax liability. When I mention planning for your estate throughout today's presentation, I am referring to your taxable estate, all your assets. Another concept I will discuss is asset protection. In this case, how leaving your children their property and trusts protects that property from being seized by their creditors or soon-to-be ex-spouses, and in some cases from being subject to estate claims when they die. Our second section, estate planning yesterday and today. 30 years ago, most Americans used a will as the centerpiece document to plan their estates. They were merely leaving what they had to whom they wanted when they died. Their wills were simply distribution plans, effective only upon death. The problem with will-centered plans was, and continues to be, the probate process, which is the procedure by which your local probate court enforces your will. Also, up until 2001, most families were concerned about federal estate taxes. This is so because individuals owed estate taxes on estates valued as low as $600,000. Again, as we discussed earlier, your estate consists of your financial assets, house, ATRA, and retirement plans and life insurance policies. You can see why estate taxes became the primary focus of estate planning, even for middle-class families. Also, about 20 years ago, families began to focus on the high probate fees typically associated with will-based planning. By the way, here in the state of California, probate fees are percentage-based on the entire gross estate value and could range from thousands to millions of dollars. With the increase in internet use and the public recording of wills and probate records, families began seeking ways to protect their privacy. Probate avoidance became a standard goal of estate planning to eliminate the publicity and fees associated with will-based planning. Revocable living trust planning has gained acceptance as the primary estate planning document. This is so because a revocable living trust can distribute your estate privately with no probate court involvement, keeping your estate private and protecting your heirs from unwanted attention. Lastly, in the past few years, incapacity planning has been in the spotlight. Traditionally, estate planning provided very little counseling in this important area. As you consider planning for your estate, you will want to work with a counseling-based estate planning attorney who will draft a disability plan for you that protects you and provides for you and your loved ones during a time of incapacity. There have also been significant changes to the estate tax laws. Three of the biggest changes include: first, there is an exemption of $11.7 million per individual or $23.4 million per married couple on federal estate taxes. However, if the Congress does not extend this exemption, its limits will expire and reset to the prior laws in 2026. This reset will restore the estate and gift tax exemption amount to $5 million, as it was in 2016, though it will be indexed for inflation, resulting in an exemption amount of approximately $6.6 million per individual in 2026. Again, this is the law as it stands today. Without further action from the Congress, it will remain the law. Second, the maximum marginal estate, gift, and generation skipping tax rate has been reduced from 55% to 40%. Third, in the past, if a person did not include federal estate tax planning in his or her estate plan, their surviving spouse was often left with an estate tax problem at their passing. Today, a surviving spouse can preserve the deceased spouse's exemption amount, thereby being able to live twice the exemption amount estate tax-free without having to set up a bypass trust or file an estate tax return when the first spouse dies. In many cases, this simplicity outweighs the benefits of the traditional bypass trust plan. As you can see, the way Americans have planned for their estates has evolved over the past 20 years. We are no longer focused only on estate tax minimization. We are now able to focus on the issues that matter most to families, which are designing a plan that produces family harmony, including comprehensive disability planning, designing a plan that creates a legacy, including values that should be passed down from generation to generation, drafting an estate plan that provides important asset protection for a surviving spouse, children, and grandchildren, and lastly, drafting an estate plan that is as tax efficient as possible, planning for estate and income taxes. Section 3. What you need to know about wills and trusts. There may be instances where a will-based plan is the best option. One example would be an estate where litigation is expected. A probate court is the best process to oversee this litigation and can provide the structure needed to settle the dispute. As we discussed in the previous section, many individuals are looking for a better way to plan their estate. Some risks associated with will-based planning include: traditional will-based planning provides little guidance for disability planning. A financial power of attorney must also be drafted, and most financial powers of attorneys do not include instructions for the care of the individual as well as authority to provide for the needs of anyone other than the individual signing the power of attorney. Another risk of will-based planning is that many assets are outside of the reach of a will and often go unplanned for. Wills do not control most property, including retirement plans and insurance policies. Lastly, because a will is only used to transfer property at death, If any custom planning is included for beneficiaries, trusts are going to need to be created. We've mentioned probate throughout our presentation. A will-based plan has some significant shortcomings for families that value privacy. Because a will must be filed in the county courthouse in order to be administered, the act of probating a will exposes your loved ones to unwanted attention. The entire world now knows their names as well as the amount of money they just inherited. Other facts about the probate process include: the probate process has court-imposed deadlines and responsibilities for your executor. Many executors find this process complex and hire a probate attorney to provide guidance throughout. Also, because of the court-imposed responsibilities, the process can be long, often several months to a year to complete. Because of this, probate fees typically associated with will-based planning are percentage-based in California, ranging from a few $1,000s to millions, depending on the estate value. Let me explain what I mean when I mention expensive probate fees. Probate fees in California are found in California Probate Code and are percentage based on the total gross estate value. The gross estate is the value of your assets before deducting any debt associated with the assets. On this chart in the right column, you can see how much you might have to cover in probate fees based on the gross estate value listed in the left column. As seen, on a $500,000 estate value, you can end up paying around $26,000 in probate fees. And on a $3 million estate value, which is more common in California, you would end up paying roughly $86,000 in probate fees. I think you can find better ways to use such big amounts instead of giving them away to probate attorneys and executors. Don't you think so? The probate court may also become involved in your life if you fail to properly plan for a period of mental incapacity. Probate court is authorized to name a guardian on your behalf. That person would then be authorized to manage your finances and make healthcare decisions for you. This process can take control away from you and your family, as the court is under no obligation to name a spouse or trusted child to this position. The process can also be very expensive, as the individual named is often compensated for their time. Time not only managing finances and healthcare decisions, but also time required to produce reports to the court. We mentioned earlier in the presentation that a will does not control every asset that a person owns. One example of this is assets owned as joint tenants with right of survivorship. With an asset owned joint tenants with right of survivorship, the last person alive owns all the property, not the partial ownership they began with. It is, however, included in the value of your estate for calculating any federal estate taxes owed. Also, because the will does not control the asset, it is not subject to the probate court, and the last person alive who now owns the asset cannot be legally compelled to give back the portion of the asset they just received as a joint tenant. This type of ownership often produces unintended heirs, or a disproportionate share of an estate going to one individual. In my experience, many clients believe their estate planning distributes their estate equally among beneficiaries, only to learn, once it's too late, that an asset was owned as a joint tenant with the right of survivorship and will not be distributed according to the terms of the will. It is important to note that this approach does not avoid probate totally. The asset will need to be probated at the death of the second owner, but it will be distributed according to the second person's estate plan, not the plan of the first to pass away. Lastly, there can be unintended income tax consequences with joint tenancy. Because the asset does not pass through the estate, the cost basis of the asset does not get the benefit of stepping up to the value of the asset at the time of the person's death. This is a tax benefit only available to assets passed through the probate or trust administration process. Then, when the asset is sold, there may be additional capital gains taxes owed. You can see why in our practice we recommend a comprehensive plan. We believe it provides the best option for efficiently passing assets to your heirs. These assets all have a similar manner of passing to your beneficiaries at the time of your death. 401k plans, life insurance, payable on death, transfer on death accounts, and IRAs all allow you to name the person you want to receive the money in a particular account on your death. This is commonly referred to as checking the box. Because these assets direct the asset to a designated beneficiary on your death, they do not pass through the probate process and are not subject to the terms of the will. Great care must be taken to ensure that the designated beneficiaries of IRA, 401k, TOD, POD, and life insurance match the planning in your estate plan. Otherwise, you can quickly cause problems for your loved ones. One of the biggest examples is when designating a spouse, child, or grandchild as an individual beneficiary, and trusts have been drafted to create asset protection for these beneficiaries. If asset protection is a priority, then the designations need to be updated to name the beneficiaries' trusts as the beneficiaries of the assets. Assets given directly to the spouse, child, or grandchild have no asset protection. Another risk is that of unintended beneficiaries, or one beneficiary receiving more inheritance than you intended. Because these assets are distributed outside of the probate process, the terms of the will do not have any control over the distribution. It is important in a proper drafted estate plan to make sure that the beneficiary designations are properly aligned with the estate plan. Only then does a person truly have control of their estate plan. We have talked about the potential risks associated with will-based estate planning. I would like us to turn our attention to living trust-based planning and when this type of planning might be appropriate. You should choose a trust when you value First, an estate plan that will take care of you during your life, not just at death. Keeping control over the plan during your lifetime, and planning for mental disability, including how you want to be taken care of and who will make those decisions on your behalf. You should choose a trust when you want to provide planning for your descendants, considering whether the inheritance should be given outright, in stages at certain ages, or in a lifetime trust providing the beneficiary protection from himself or herself, creditors, predators, and divorce. Because a lifetime beneficiary controlled trust is not an asset that is owned by your child or grandchild, it has a level of protection against creditors of your beneficiary. Protections can even include protection from a divorcing spouse. While the beneficiary does not own the assets, your spouse, child, or grandchild may serve as the trustee of the trust, providing him or her with a level of control over their inheritance. In my experience as an estate planning attorney, planning for distributions to descendants is one of the most important aspects of an estate plan. With a trust, you can design a custom plan to distribute your estate at the time of your death, providing comfort and asset protection for a surviving spouse, caring for minor children in the event they need to be raised by guardians, providing an inheritance with protections to adult children and grandchildren. If you have an existing will or trust, or are considering your first estate plan, the best way to retain control of your estate and provide for your loved ones is by designing a customized plan for your beneficiaries. This is possible when using a living trust as your primary estate planning document. When planning with a trust, you also have the opportunity to plan for your personal values. When working with clients, I realize that they're often interested in honoring their church, synagogue, and charities. In addition, special care needs to be given to planning for pets. We can counsel on the best way to plan for the care of pets should your pet survive you, as well as passing the firearms to the intended beneficiaries. A trust gives you control and allows you to plan for these important values in your estate plan. There are also laws that govern the transfer and ownership of firearms. Often, it makes sense to use gun trusts to own assets and preserve family heirlooms for generations to come. When planning for charity, pets, or unique assets like family firearms, it is important to work with a lawyer comfortable with trust-based planning in order to maintain control. When planning with a revocable living trust, you can save money by avoiding probate costs. This is because the revocable living trust replaces your will as the estate planning document used to distribute your estate at the time of your death. In order to completely avoid probate, your assets are titled into the name of your revocable living trust. You maintain complete control of your assets as the trustee of your trust while you are alive and well. In the event of your disability or death, control of and distribution of your trust is handled through successor trustees. In addition to saving money by avoiding probate, your trust can also save you money by drafting to take advantage of all the deductions and exemptions available under the tax laws. Comprehensive estate planning is not complete without providing solutions for asset protection and income tax planning. When it comes to providing asset protection to individuals and families, there are many planning options available. The most essential planning option is having the basic protections in place. During the estate planning process, we encourage all of our clients to have a comprehensive insurance review with an insurance professional. Insurance is often the best option to provide for long-term care, medical expenses, and general liability. We also recommend that all business interests are held in a corporate structure to protect the business owners from any liabilities of the business. In the area of estate planning, spouses are often best protected through a bypass trust. A bypass trust can provide for a surviving spouse while offering him or her asset protection from creditors. We also recommend irrevocable trusts for protecting life insurance, commonly called as ILITs, as well as various trusts to protect an individual's assets during their lifetime, such as domestic asset protection trusts and beneficiary defective inheritors trusts are two of the trusts that will provide asset protection and income tax planning for assets that are in an estate plan. It is important to remember that there are many trusts available to reduce income taxes and provide asset protection. If asset protection is one of your goals, you are going to want to review your current estate planning with a qualified estate planning lawyer as soon as you are able. You should discuss with your estate planning attorney all your asset protection and income tax planning needs. This brings us nicely into the fourth section of our seminar, how to find the right attorney. I have developed a series of questions that will assist you as you consider this important process. Is the attorney's primary focus on estate planning? As you have learned throughout today's seminar, estate planning touches on every area of your life, your values, family, relationships, your finances, your legacy. An inexperienced attorney may not recognize issues that need to be addressed in your estate plan. You need to work with an attorney whose primary focus is on estate planning. This will help ensure that counseling and documents you receive will be appropriate for you and your family. Does the attorney work with your other professionals? We have seen today how an individual's assets need to be properly aligned with the estate plan. In our experience, if the attorney does not work with other professionals, it is more difficult to accomplish the cost savings, asset protection, and tax planning objectives. Does the attorney charge a flat fee or an hourly rate for providing estate planning or other services? This is an important question to ask, so you won't be surprised by hidden fees and costs. These days, the majority of estate planning attorneys charge a fixed fee for most, if not all, of their services. This will give you the peace of mind to know the flat fee is all that you'll be required to pay. You will need to understand, however, what the flat fee does and does not cover, and when the attorney might charge an additional flat fee or start billing you on an hourly basis. What is the attorney's process for keeping your plan in place? Estate planning laws continue to change. Family finances and personal goals continue to change as well. When selecting an estate planning attorney, be sure to ask that attorney what his or her process is for keeping the plan current with the law and with your personal family dynamics. Many estate plans fail because they are out of date and don't reflect the wishes of the individuals, or they don't take advantage of all the options available for asset protection and estate tax savings. Ask yourself, can I see myself working closely with this attorney? Even if the prospective attorney answers all of the other questions to your satisfaction, this is the most important question that you need to ask yourself. If you're not comfortable with this specific attorney, then chances are you won't be happy with the attorney's work. But don't be alarmed. It's better to determine this sooner rather than later. Simply move on until you find an attorney who you feel comfortable enough to plan your family's future. You should also speak with your estate planning attorney to understand what he or she considers comprehensive estate planning. As we have learned today, a comprehensive estate plan is more than simply having a signed will. It includes a fully funded revocable living trust, giving you complete control while you are alive and well, providing instructions for your care during a period of disability, and privately distributing your estate at the time of your death to your beneficiaries. Additional documents that should be drafted with a living trust include a pour-over will, where you name guardians for minor children and direct any assets that might not have been funded properly to be distributed to your trust. A healthcare power of attorney to give another person the authority to make healthcare decisions on your behalf. A durable power of attorney to give a person of your choosing the ability to legally manage assets not funded into your trust. Examples include IRA and 401k assets, memberships, and filing income taxes. A living will. This document is where you instruct physicians if you would desire life-sustaining measures in the event you are in a terminal condition. A HIPAA release allows your medical condition to be disclosed to others, including family members who, under the HIPAA laws, otherwise would not be able to get health information from your physician. Current HIPAA laws prohibit doctors from discussing the health of a patient with anyone, including family members, unless the patient has signed a release. This document can be important if you have family members that you would like to keep updated on your health. A personal property memorandum is typically referenced inside of a trust and is used to give personal property to family members and friends. Without this important document, many families struggle to distribute the personal property in a fair way. Memorial instructions and a legacy statement are important to the success of any estate plan. This is where a client can pass on family values to the loved ones. Memorial instructions can include what passages of scripture or poems should be read, who should speak, and what music should be present. A legacy statement is an opportunity for a person to give not only financial assets to a beneficiary, but a lifetime of experience and guidance, a chance to invest values into your beneficiaries. As you can see on the last slide and from today's discussion, estate planning should be done by an estate planning attorney committed to providing a comprehensive estate plan. There are less qualified options available today for families that might not know better. In the legal community, we refer to these options as bare bones trusts. They are often produced by attorneys who do not focus on estate planning, or not even attorneys. Be aware of these documents, as they might not comply with the state law. They do not contain the important personalized planning to protect you and your family, and typically are not even funded. Because they are not funded, the estate will still be required to go through the probate process. This slide illustrates how I design and draft comprehensive estate plans for my clients. Our first meeting is the initial client meeting. During this meeting, we discover the goals and objectives of our clients. We also learn about the client's estate and family members. We also learn who the client's other professional advisors are and get permission to contact them. Our second meeting is the design meeting. Our time in this meeting is spent educating clients on the estate planning options available to them and counseling them as they identify what planning options they want included in their plan. The third meeting in our process is the delivery meeting. During this meeting, we review the major provisions of the trust with the clients, showing where their personal planning goals are represented in the document. We also review the ancillary documents like the healthcare power of attorney and living will to ensure that they are drafted exactly as the client desires. After reviewing the documents, they are signed and notarized. After the estate plan is signed, we then make sure that the plan is implemented. This includes working with the client's other advisors to make sure that the plan is funded properly and making sure that the proper financial and insurance reviews have taken place. Then, on an annual or once in 3 years basis, if chosen by the client, we provide a client care program that provides estate plan maintenance for our clients. This service is designed to keep our clients' plans up to date with the estate planning laws as well as their family and finances. In the past, many people put off estate planning as a negative event that they should avoid. Let's close our time together with a discussion on when is the best time to plan. I understand that estate planning has historically been viewed as a necessary evil. However, comprehensive counseling-based estate planning solves that problem. Estate planning is now an opportunity that you don't want to miss. The usual excuses that you might encounter are: estate planning is a luxury, not a necessity, I don't want to think about it, it costs too much, or I don't have the time, I don't have enough property, I don't like even attorneys, I'm going to do it myself. But all these excuses don't make any sense because our clients find that our process provides value no matter the size of the estate or family size. And with the disability planning, asset protection, tax saving options available for families today, it is more important than ever to have a comprehensive estate plan now. It is important to note that each one of us has a will, whether you have signed one or not. If you have not signed one yourself, the state of California has drafted one for you by default, by enacting statutes that say who will inherit from you since you did not say so yourself. If you die without a will, you die intestate. Sections 6401 and 6402 of the California Probate Code provide the general rules of intestacy succession in California, based on which, if there is no will or trust in place, the deceased property and money is distributed to his or her heirs as follows. First, everything to spouse or domestic partner if the deceased has no surviving issues, meaning all children and children down through generations, no parents, no siblings, and no issue of the deceased siblings. Second, if the survivors are the spouse or domestic partner and one child or issue of deceased child, such as a grandchild, all community and quasi-community property goes to the spouse or domestic partner, and half of the separate property goes to the spouse or domestic partner, and the other half of the separate property to only one child or issue of the deceased child. Third, if the survivors are the spouse or domestic partner and more than one child, or one child plus issue of one or more deceased children, all community and quasi-community property goes to the spouse or domestic partner, and 1/3 of the separate property goes to the spouse or domestic partner, and 2/3 of the separate property to children or issue of the deceased children. 4. If the survivors are the spouse or domestic partner, the parents, and no children or their issue, all community and quasi-community property goes to the surviving spouse or domestic partner, and 1/2 of the separate property goes to the spouse or domestic partner, and the remaining half to the parent or parents. Due to the limited scope of this presentation, I'm simply not able to list all default rules of intestacy succession in California. However, if you rely on intestacy succession, no will and no trust in place, you will also lose control over who manages your estate. A court-appointed administrator will be selected by the court. This leads to higher fees and less money for your heirs. You will also lose control over naming a guardian for your children if you have minor children. If you are wondering if today is a good time to plan your estate, I have listed a few occasions in life when it would be a good idea to complete your estate plan. First, child is born, children reach the age of majority and can serve as decision makers, grandchildren are born, parents are aging and have more definite plans regarding when and how they want their property to pass. Additional life events that should trigger the completion of the estate plan. A child turning the age of majority should have a durable power of attorney and healthcare documents in place. A financial windfall, such as winning the lottery or inheriting wealth, has occurred. Death of a spouse or a child, a change in the relationship to a decision maker. If any of these have occurred in your life, now is a good time to plan your estate. Many in our audience today likely attended in order to review their existing estate plan and hear what is currently available with a comprehensive estate planning. If you have an existing estate plan and you're not sure of the following, you should consider having your estate plan reviewed. First, if when planning your estate you don't remember creating personalized instructions for your care during disability. Second, if your plan lacks the comprehensive planning options for your spouse, children, and grandchildren, including asset protection and tax planning. Third, if the persons named as power of attorney, trustee, or executor are no longer the best choices. And four, if you're not sure that your assets are properly aligned with your current estate plan. As we close our time together, remember, estate planning has come a long way in the past 30 years. Comprehensive estate planning is now much more effective and efficient at meeting your legacy goals. Estate planning is a critical part of any comprehensive financial plan, and it is important to work with an attorney whose focus is estate planning and who has a process for keeping your plan current even after it was signed. As for the future, your task is not to foresee it, but to enable it. Antoine de Saint-Exupéry. If you have any questions about this presentation, please email them and I will gladly respond when time permits. I serve both in-person and remotely clients from all over California. I cannot wait to begin working on your estate plan, and you are only one call or email away from having a plan done for your family.